My wife was 8 months pregnant and resting at home when an HOA officer decided to let herself in. She didn't knock, didn't ring the bell. She simply unlocked the door and strolled in as if the deed to the house were in her name. My wife screamed, and the intruder screamed right back. By the time I received a frantic phone call, my brother, who happens to be a litigation attorney with a notoriously short fuse, was already on his way. The absurdity of the entire ordeal can be traced back to something as trivial as paint. Not hazardous paint, not anything inappropriate. Just a gentle lavender shade used in our unborn child's nursery. According to the Neighborhood Association's guidelines, it was marginally different from the approved tone, and this triggered a campaign of harassment. I had moved to Maple Ridge Estates with the expectation of calm suburban living, meticulous lawns, neighborly greetings, children pedaling down the street. What no one mentioned was that the HOA president treated the subdivision like her private empire, patrolling daily in a golf cart outfitted with official-looking decals, and even a horn playing Beethoven. From the moment she discovered our lavender nursery walls, she began issuing citations for increasingly ludicrous reasons. Our curtains were deemed aesthetic violations because they looked too cheerful. The fragrance from jasmine on our porch was categorized as a suspicious scent. At one point, she even claimed our backyard felt secretive, as though landscaping could be accused of conspiracy. Each notice was handed out with a smirk, like she enjoyed enforcing rules only she seemed to understand. When we refused to repaint the nursery, her tactics escalated. A surveillance camera appeared on a lamppost, conveniently pointed at our mailbox, supposedly to deter package theft. A drone began hovering over our yard during dinner, which she insisted was for gutter inspections. The boldest move came when she knocked on our door early one Saturday and demanded to inspect the nursery personally. We refused. She promised a return with documentation. We assumed she meant legal paperwork. Instead, she returned with a master key. On the day of the incident, while I was out buying diapers, she let herself in under the pretense of verifying window tint compliance. My wife, heavily pregnant, found her standing in the living room with a clipboard and color wheel. Terrified, she screamed. The intruder scolded her for violating noise ordinances. While my wife sobbed on the phone with 911, the HOA president continued rattling off bylaws as if that justified her trespassing. My brother David, the litigator, arrived before the police. Calm but visibly furious, he began recording every word, carefully prompting her to confirm that she believed her position gave her access to private residences. That same afternoon, he filed for a restraining order. The legal unraveling was swift. Within days, David uncovered that the HOA board had been distributing master keys illegally, a massive breach of state statutes and insurance regulations. He subpoenaed the security contractor, who admitted under oath that the president had pressured them to duplicate keys despite explicit warnings. Evidence soon surfaced of several other residents whose homes had been entered without consent. The fallout was immediate. Liability shifted squarely onto the HOA leadership, and their insurance provider faced exposure for covering activities they had expressly prohibited. In less than 72 hours, what began as harassment over a paint color transformed into a full-scale legal crisis for the association. Would you like me to refine this further into a polished short story style narrative, something with more dramatic pacing and vivid imagery? Or would you prefer it structured as a legal case-style account emphasizing procedural details and violations? David quickly realized the problem went far beyond our house. He began organizing a class action with several neighbors who had their own unsettling experiences. An elderly couple admitted that while they were on vacation, the HOA president had entered their home and rearranged their furniture for better flow. Another neighbor produced video footage showing her walking inside just to leave violation notices on the kitchen counter instead of mailing them. In retaliation, she attempted to fine everyone involved for something she called weaponized legalism, a term she invented and printed on her own fake HOA stationery. As David dug deeper, the truth grew uglier. She had been forging signatures of fellow board members for years, making decisions entirely on her own. She approved overpriced contracts for her cousin's landscaping company and misused emergency funds to buy a wine fridge, which she kept locked away for her private use. The other board members claimed they assumed she was simply efficient and never questioned her. David called it negligence at best, outright fraud at worst. Faced with mounting evidence and the threat of criminal charges, the HOA board held an emergency meeting. 17 homeowners showed up, each with grievances of their own. She tried to claim the meeting was invalid because it hadn't been scheduled a month in advance, but the board finally overruled her. Even her usual allies voted against her. The result was unanimous. She was stripped of her role. Lawsuits followed, including one from the HOA's insurance company. The Attorney General's office got involved, banning her from ever holding another financial or leadership position in the state. The neighborhood celebrated the end of the Master Key program by hiring a locksmith to toss the spare keys into a wood chipper. Neighbors cheered while she stood nearby, shouting that property was being destroyed. Court orders kept her at least 50 feet away from any board member, so all she could do was take pictures and yell. When the new board sent everyone replacement locks, the cost came from her settlement. She even attempted to pay in pennies, which the court flatly rejected. Her criminal case moved swiftly. She faced multiple counts: breaking and entering, trespassing, fraud, and embezzlement. The prosecutor built her case methodically, presenting video from half a dozen homes where she had walked in uninvited. The most damning evidence was her own obsessive record-keeping. In neatly organized binders, she had documented more than 300 unauthorized entries, complete with ratings of households and notes such as requires immediate intervention or shows dangerous signs of nonconformity. One entry about us stated, "The Kesslers demonstrate independent thinking and must be controlled before others copy them." When the prosecutor read that aloud, the jury sat in stunned silence. Her defense crumbled. Her lawyer tried to argue that HOA bylaws granted her special authority, but the judge pressed him to cite a single law to support the claim. He had none. She interrupted constantly, whispering to her attorney, at one point demanding to represent herself. The judge denied the request, calling it a stalling tactic. Her lack of remorse was obvious. Even during sentencing, she interrupted proceedings twice to correct the spelling of HOA terms in the transcript. The judge, who lived in a similar community himself, showed no sympathy. He told her flatly that breaking into people's homes under the guise of protecting property values was not oversight. It was harassment with a clipboard. She was sentenced to 18 months in prison, 3 years of probation, and ordered to pay $47,000 in restitution, including $25,000 in punitive damages for entering homes where pregnant women, children, and elderly residents had been present. When she fainted at the announcement, the bailiff rushed to help her stand. Still defiant, she muttered that she wanted to file a complaint against the judge for emotional distress. That earned her an additional 3 months for contempt. As she was escorted away, she asked the bailiff if the prison had an HOA she could join. "Would you like me to make this rewrite tighter and faster paced, like a dramatic short story, or more formal, like a case report?"